Hi there. Thanks for tuning in to the Freedom Update. This is a really exciting week for me. We're starting off 2022 with an appearance at the Supreme Court of Canada as an intervener, and I can't wait to tell you about it. If you're new here, welcome. My name is Christine Van Gyn, and I'm the litigation director for the Canadian Constitution Foundation, which is a legal charity that fights for fundamental freedoms in Canada. I upload videos about our ongoing cases and about other interesting constitutional issues in Canada. If that sounds like something you'd be interested in, please hit like and subscribe below, and that really helps my videos out a lot. But please remember, my videos are for informational purposes only. They are not legal advice. If you have your own legal question or problem, please consult your own lawyer. I hope everyone had a really wonderful Christmas and New Year's and got a little bit of a break. My break wasn't so great. Like so many other people in Ontario, I caught COVID over Christmas. And so my Christmas was pretty lonely. But we have a new year now, and I'm hoping that 2022 is going to be better. If you want to know more about the COVID vaccine, I'm vaccinated. I'm really happy that I made that choice. I encourage you to speak to your primary care physician about it. Now, you may notice that I'm not in my usual office. That's because I'm with my family up north during this latest lockdown in Ontario so that I can get help with childcare and continue to do my work for the Canadian Constitution Foundation. So I'll try to edit out any sounds of a small child yelling in the background, but if you hear it, please accept my apologies. We're all doing the best that we can. Okay, so now let me tell you about this exciting new case that we have at the Supreme Court that we're intervening in. The case is between the Attorney General of British Columbia and an organization called the Council of Canadians with Disabilities. The underlying litigation is about a constitutional challenge to some mental health legislation in British Columbia called the BC Mental Health Act. Now, this isn't what the Supreme Court case is about, but I'll explain the context for you a little bit. Basically, under that law, individuals who are detained are deemed to consent to treatment, and they're not entitled to a representative who can make determinations about their consent to treatment. Now, this goes against the usual approach to consent to medical treatment, where people are entitled to consent to medical treatment unless it's demonstrated that they cannot give consent, in which case a representative makes medical consent decisions for them. So the Council of Canadians for Disabilities was concerned with this legislation, specifically that it violated charter rights, the right of life, liberty, and security of person, and the right for equality. So the Council of Canadians with Disabilities decided to challenge this law along with two individuals, and they brought a constitutional challenge. Now, those two individuals were going to be directly affected by the law, but partway through, they dropped out of the case. It really takes a lot of guts to put your name forward in litigation like these two individuals had. Now, at the Canadian Constitution Foundation, we work all the time with individuals and applicants who are suing the government. For example, we worked with individuals who were hurt by the federal quarantine hotel policy because they needed to travel for compassionate reasons like a funeral or end-of-life care. We're working right now with individuals in our challenge to the BC vaccine passport policy. And being an applicant can be really frightening for a lot of people. It means that your name is public. There may be media coverage about you specifically. You may need to do an examination for discovery where government lawyers ask you questions, and you need to provide evidence to support your claim, some of which can be really personal information, including medical records. Now, that's what has happened in our BC vaccine passport case. Our individual applicants have to disclose voluminous medical records, and that can feel really scary and uncomfortable for a lot of people. So I have so much respect and admiration for people who will put their names forward like this. Now, in the case at hand, the Attorney General of British Columbia and the Council of Canadians with Disabilities, the two individuals originally put their names forward, ultimately withdrew their names after the Attorney General requested their medical records. But the Council for Canadians with Disabilities still believed that they had a strong case, even without those individual applicants. Now, I don't have any opinion on the underlying law about whether it's constitutional or unconstitutional, but the Council of Canadians with Disabilities is a not-for-profit organization founded to advance the rights of people with disabilities. They're a sophisticated litigant with significant experience related to law reform and litigation. The council decided to continue to challenge the law, even without the individuals, as what is called a public interest litigant. They did this using something called public interest standing, which allows litigants without a direct interest to bring cases respecting public interest issues. As a public interest litigant, the Council of Canadians with Disabilities could bring the challenge as an organization instead of as an individual. There's a test for public interest standing, and it is that test that's now being considered at the Supreme Court, and it's the issue of the scope of that test that the Canadian Constitution Foundation is intervening in. I cannot emphasize how important this issue is for organizations like mine, the Canadian Constitution Foundation. If the test for public interest standing is too narrow, we would not be able to do a lot of the work that we do. For example, in a case that was decided last year, we challenged the federal election law that imposed large penalties on people who published what the government calls false statements, including statements that they didn't know were false. The court found that that law was indeed unconstitutional and struck it down. I did a Freedom Update about that case, which I'll link below in the description so you can learn more about it. We did that case, though, as a public interest litigant. We didn't have an individual applicant. Without the ability to bring that case as a public interest litigant with public interest standing, we would have needed to wait for someone to be punished under that law, which comes with a term of imprisonment and up to $50,000 in fines. So public interest standing is really the cornerstone of charter litigation. It's the vehicle through which litigants can challenge government action that has broad social effects. It enables litigants like the CCF to bring a case notwithstanding our lack of direct involvement in a matter or any infringement to personal rights. As one of Canada's leading defenders of the constitutional rights and freedoms of Canadians, we are going to be arguing at the Supreme Court in favor of a broad framework for public interest standing that is flexible and purposive. This will enable courts to remain nimble and allow organizations like the CCF to effectively litigate serious constitutional issues, which ultimately is in the best interest of justice. A liberal and generous interpretation of the requirements for public interest standing is necessary to ensure access to the courts for Canadians who can't effectively litigate issues of importance to themselves and to the wider public. Public interest standing allows sophisticated litigants like the CCF to bring cases on behalf of Canadians before waiting until an individual has experienced the harms of having their rights violated. We're going to argue a few specific things at the Supreme Court. First, we'll argue that public interest standing shouldn't be tied to the presence of a private litigant, particularly in charter cases. We are also going to argue at the Supreme Court that the term public interest is itself a complex concept that is constantly shifting and evolving, and therefore there needs to be a flexible approach to determining if a litigant has public interest standing. We will also be arguing that experienced public interest organizations like the CCF can often be better equipped plaintiffs. Organizational litigants can often have more resources and expertise, including access to experience and skilled counsel who can make sure that the litigation is conducted in an orderly and sophisticated manner. For example, the election speech case I mentioned earlier shows the important role organizational plaintiffs can play in constitutional challenges, even without affected individual plaintiffs. It's unclear how, in that case, denying us public interest standing, just because hypothetically another individual could have brought it, would have been in the best interest of justice. It's actually the opposite is true. By giving the CCF standing in that case, we could effectively and efficiently litigate the case and enhance the interests of justice, even in the absence of an individual plaintiff, and we were able to do this before any individual suffered rights violations. If you're interested in watching the Supreme Court hearing, it takes place on January 12th and 13th. You can stream it on the Supreme Court's website, which I've linked below. And you can follow me on Twitter. My Twitter handle is below. I'll be tweeting out the links and some updates as the case progresses. You can also read our factum, which I've put below in the notes. And if you sign up for our Freedom Updates, you'll be notified once there is a result in this case, as well as stay updated in all our other cases. Well, that's all for this update. Thanks for tuning in, and let's keep fighting for freedom in Canada.